All right, welcome to class, counsel, law students, and neophyte lawyers. Settle in. Today, we're putting on our litigator hats and stepping right into the courtroom. We are diving super deep into the Supreme Court's AM number 01701-SC, which establishes the rules on electronic evidence in the Philippines. Think of this as your ultimate tactical guide, a masterclass for wielding electronic evidence effectively. Because, let's be real, in an era where cases are won and lost on emails, text messages, and digital logs, knowing how to get a digital file from your client's hands directly into the judge's record isn't just useful, it's an absolute necessity.
So here's our syllabus for today's explainer. We're going to cover scope and definitions, the digital best evidence, authenticating documents, weighing evidence, navigating hearsay and ephemeral communications, and finally, electronic testimony.
Now, before we get completely lost in the technical weeds of cryptography and server logs, keep this foundational directive from Rule 2, Section 2 in the back of your mind. You see, the Supreme Court actively wants to accommodate our modern digital reality, not obstruct it. The ultimate goal is a just, expeditious, and inexpensive determination of cases. This is basically your shield when opposing counsel tries to use archaic technicalities to block your clearly relevant digital evidence. Okay, Section 1, Scope and Digital Definitions. Let's master that digital vocabulary.
The rules of the game have totally changed, and honestly, so has the language. You really have to forget your traditional concept of paper. Under Rule 2, an electronic document is literally any information, whether it's data, figures, or symbols, that establishes a right or proves a fact and is produced or stored electronically. And notice the absolutely crucial inclusion here. An electronic document includes any printout or output readable by sight which accurately reflects that electronic data. It's considered a functional equivalent to the digital code itself.
Now, moving on to signatures, we absolutely have to distinguish between a generic electronic signature and a true, capitalized digital signature. Make no mistake, counselors, a digital signature isn't just some JPEG of a scanned pen stroke you copy-pasted onto a PDF. As the rules define, it's a mathematical transformation using an asymmetric or public crypto system. This highly secure method proves two essential things: the absolute identity of the sender who used their private key, and that the initial electronic document has not been altered since that transformation was actually made. To really wrap your head around that crypto system, you kind of need to understand the key pair. Think of it like this. The private key is your client's super secret, mathematically generated digital stamp. They use it to seal the document. And the public key? Well, that's the mathematically related tool available to everyone else. The court or the receiving party uses that public key to verify that the specific private key was indeed the one used to stamp the document. It's like a giant puzzle where the pieces fit perfectly together. Moving to Section 2, the digital best evidence. Counsel, picture this. Your client brings you a physical printout of a highly incriminating email. You offer it into evidence, and opposing counsel immediately shoots up and objects, citing the best evidence rule, demanding you bring in the original computer server. So, how do you respond? You confidently hit back with Rule 4, Section 1. This rule clearly dictates that an accurate printout or output readable by sight is legally regarded as the exact equivalent of an original document under the best evidence rule. You do not need to literally drag the physical company's server into the courtroom on a dolly. As long as you can show the printout reflects the data accurately, you are holding the digital equivalent of a paper original.
And hey, what if you just have an electronic duplicate? Like, say, a file copied onto a standard flash drive? Well, Rule 4, Section 2 provides that identical electronic copies, or duplicates, are fully admissible to the exact same extent as the original. There are literally only two exceptions. If opposing counsel can raise a genuine substantiated question as to the authenticity of the original, or if, under the specific circumstances, it would be unjust or inequitable to admit the copy instead of the original.
All right, Section 3, Authenticating Documents and Signatures. Time to build that bridge of trust. Because, simply having an original doesn't mean it automatically gets admitted. Rule 5 states that the burden of proving an electronic document's authenticity rests entirely on whoever is trying to introduce it. Section 2 gives you your tactical checklist. Before any private electronic document is received in evidence, you've got to prove its authenticity by at least one of these three ways. First, by evidence it was digitally signed by the purported person. Second, by showing that appropriate authorized security procedures were applied. Or third, the big catch-all, by presenting other evidence showing its integrity and reliability to the complete satisfaction of the judge. And if you do successfully take that first route and authenticate a digital signature, well, Rule 6 arms you with some massive disputable presumptions.
The law will literally presume the information in the certificate is correct, that the signature was created during the operational period, that the certificate is totally valid, and crucially, that the message hasn't been altered from the time it was signed. This shifts the heavy burden of proof right back onto the opposing counsel to prove otherwise. It's a real game changer.
Section 4. Weighing the digital evidence.
Because admissibility is definitely not the same as weight. How do we strategically convince the judge to give our electronic evidence maximum evidentiary value? Well, Rule 7 provides the exact rubric for this. The court is going to actively scrutinize these factors. They'll look at generation and storage. How reliable were the inputs and accuracy checks? They'll look at how the originator was actually identified. They'll question system integrity. Was the hardware and software reliable and free from bugs and programming errors? And, really importantly, witness familiarity. Whatever you do, don't put a witness on the stand who doesn't understand the software. You've got to prepare them to speak confidently on the system itself.
Okay, Section 5. Hearsay and ephemeral communications. Let's overcome some major roadblocks. Hearsay. Literally every law student's worst nightmare, right? The fundamental rule of evidence states that out-of-court statements offered to prove the truth of the matter asserted are generally inadmissible hearsay. Electronic records, since they're generated outside the courtroom, fall squarely into this trap. So how do we bypass this massive roadblock? Thankfully, Rule 8 provides a pretty brilliant exception. The hearsay rule simply doesn't apply to a memorandum, report, or data compilation if you can prove a few specific things through the testimony of a custodian or qualified witness. You basically have to show the electronic record was made at or near the time of the event by someone with actual knowledge, that it's kept in the regular course of business, and that it was the regular practice of that business to make those electronic records. Check all those boxes, and boom, the hearsay objection is overruled. But what about a deleted Snapchat or an unsaved Zoom chat? Rule 2 classifies these fleeting moments, things like telephone conversations, text messages, chat room sessions, and streaming video or audio, as ephemeral electronic communications. This specifically applies when the evidence of these communications is not recorded or retained. So if the message totally disappeared, how on earth do you prove it existed at all? Rule 11, Section 2 gives us the answer. You simply prove these fleeting, ephemeral messages through the direct, personal testimony of a person who is a party to the communication or someone who has direct personal knowledge of it. And if those witnesses are somehow unavailable, the rules liberally allow for other competent evidence to be admitted. It relies on good old-fashioned human testimony to verify the unrecorded digital event. The ultimate backup is surprisingly low-tech.
Finally, Section 6, Presenting Electronic Testimony, the Virtual Witness. We've handled the documents, now we got to put our witness on the screen. Rule 10 is your playbook here. You can't just fire up a webcam and call it a day. You must follow protocol. First, the court has to authorize it after a summary hearing where they determine the absolute necessity and lay down conditions to protect everyone's rights. And crucially, and honestly a bit ironically for a rule all about technology, even though it's an electronic examination, the entire proceeding must still be transcribed by a human, authorized stenographer. That certified transcript, alongside the recording itself, then becomes prima facie evidence of those proceedings.
Which brings us to the end of our masterclass. We've seen exactly how the Supreme Court has seamlessly integrated the digital world into the halls of justice. A simple printout is the new original document. An asymmetric crypto system is the new wax seal. So counselors and future lawyers, here's my question for you. When you step into that courtroom, are you fully prepared to build a bulletproof chain of authentication for every single byte of data your client brings to the battlefield? Class dismissed. Keep analyzing, keep preparing, and I'll see you in the next explainer.